One of the reasons we came up with this whole lame duck watch thing was to keep an eye on the inevitable flurry of regulations the Bush administration would try to get past Congress on their way out the door, with nobody paying attention. All the stuff they've wanted to pass, but just never had the political capital to actually pass in the light of day. Well, in a somewhat delicious turn of irony, the 7-course gourmet meal of irony, perhaps, some of the regulations the Bush team thought they were slipping through, turns out they can easily be reversed by the Obama administration because, this is very, very good, their math was wrong. Their efforts to impose their will on the country and the next administration may be thwarted because they forgot to carry a 1 or something. Finally, their incompetence benefits us. Back in May, White House Chief of Staff Josh Bolten told federal agencies, hurry up, finalize your new regulations by November 1st. Now, why November 1st? Because they thought that any new regulation passed more than 60 days before the start of the new administration would kind of be written in stone and difficult to reverse. The hilarious incompetence here is that the White House either forgot or they just didn't know about something called the Congressional Review Act of 1996, which, according to Politico.com, means their math is wrong. The actual deadline for passing new regulations is long past. It was May 15th, not November 1st, meaning anything passed after May 15th can be reviewed by the new Congress and effectively quashed. Oops. So all those new energy and environmental regulations the White House was hoping to ram through Congress, like a green light for local law enforcement spying on us without criminal suspicion, the Bush administration overshot the deadline by 5.5 months or so. Now, rather than trying to push through regulations at the last minute, particularly doing so very incompetently, President Bush might want to think about what happens after he leaves office, specifically how he might handle, say, congressional investigations on, I don't know, torture, the fired U.S. attorneys. Up until now, the favored line of defense in the White House has been to claim executive privilege. In fact, that phrase is probably tattooed somewhere on Dick Cheney's body, like maybe the insides of his eyelids. But once you're out of office, no more executive privilege, right? Wrong. The great reporter Charlie Savage at the New York Times reports today that even after President Bush leaves office, he may still be able to exercise his executive privilege powers. Is this some wrinkle in the darn Constitution? Actually, no. It's darn Harry Truman. Truman's legal team basically invented this idea of post-presidency constitutional powers in 1953 when they were evading McCarthy's HUAC committee, and Congress never challenged them on it. So it turns out Bush and Cheney might be taunting us with claims of executive privilege for years to come. What happens to all of those investigations we want answers to, all of those subpoenas that have thus far been ignored? Time to call in constitutional law professor Jonathan Turley. He's a professor at George Washington University School of Law. Professor Turley, thank you for joining us tonight.
Hi, Rachel.
Exercising executive privilege after you've left office, can they really do that, really?
Well, this is very controversial. In fact, Truman's own people later questioned whether they actually did have the right that they invoked. And it really has never been tested. It's never gone to the Supreme Court. I personally have considerable doubts about it. There's no question that a former president under federal law can invoke executive privilege with regard to the release of presidential papers. But this idea that President Bush can continue to invoke executive privilege even against the position of the sitting president, I think is pretty shaky. Ultimately, a court may have two presidents in front of it, one a sitting, one an ex-president, taking rivaling positions on executive privilege. In my view, the court would be insane to take the position of the former president over a sitting president as what is required to protect the office of the presidency.
Sure, and it would be just incredible irony to see Dick Cheney arguing under the veil of his unitary executive theory that a former president somehow trumps the sitting president in terms of authority. That would be incredible. Well, if they did make a claim like that, and there were future congressional investigations into criminal activity by Bush administration officials, does that mean that they would essentially be on hold while this stuff got kicked up to the courts?
It would. They would seek an injunction, and it might be granted. And I think the Supreme Court would very likely take up the case. But I think the problem here is how much of a negative legacy does George Bush really want to leave? He's just spent the last 8 years talking about how important the office of the presidency, how important it is to support a sitting president. This would be an incredible act, a very dysfunctional and negative attack on a sitting president. But, you know, this is an administration that does not shy away from extreme positions. Remember, they've lost executive privilege arguments as a sitting president. So they may not be that afraid of losing a few as an ex-president either. They had a very conservative judge recently say that their position with regard to people like Harriet Miers was virtually absurd. So we have to wait. I mean, most of us would hope that they would have some adult supervision, but we haven't seen that in the last 8 years on these claims.
Jonathan, there is speculation today that President Bush might issue a sort of blanket pardon for people involved in his administration's decision about torture. Has anything like that ever been attempted before? Not just pardoning one person, but pardoning whole classes of government employees who might have either participated in the decision-making process or implemented that decision.
Rachel, this is one of the most scary potentialities of the waning days of the Bush administration. As you know, even President Clinton really yielded to temptation and committed some great abuses using the pardon power, using it for a family member, which was itself outrageous. But, you know, there's a lot of concern that President Bush could issue a blanket pardon for people who were involved in the torture program, the electronic surveillance program. It would create a terrible precedent. Effectively, the president would be pardoning the world. Now, we have had presidents like Kennedy who pardoned people who were convicted under a controversial Narcotics Act. We also saw pardons for draft dodgers. But this would be different. This would be a very generally worded pardon for anyone associated with these programs. If he did that, I think that he would trigger a constitutional crisis where people demand a constitutional amendment to limit the power of the president. And you wonder, you know, on one hand, being the least popular president in modern history frees you up a bit. It may even embolden you. But this would be the final, really, nail in the coffin for Bush as a president who seemed at war with the Constitution that he promised to uphold.
Jonathan Turley, George Washington University law professor, thank you for your time tonight, and I hope we never have to talk about the pardon thing again, because it doesn't happen. Thank you.
Thanks, Rachel.
Maybe